afternoon. Welcome to Top 10 Ways to Stay Out of Court. Today's presented by the Central Valley Regional HR Hotline. My name is Anna Manzano. I'm the digital media and event strategist here at the California Employers Association. Before we get into today's content, I just want to go over a couple of details for you. Your audio, as you see, is going to be muted for today's presentation, but as you're already doing so beautifully in the chat, there's going to be lots of opportunities to engage during today's session. If you have any questions about the presentation content, you can type them into the Q&A box. You can, if they end up in the chat box, it's okay. I will be helping Astrid monitor the chat today and make sure that we get all your questions answered. Handouts for this training, those I'm going to pop into. We had a last minute little update we had to make, so thank you for your patience there, but I am going to actually put the PDF into the chat box. I'll do that now, and I'll do it again at the end just to make sure everyone has access to that. When you see it pop up in the chat box, you can just click it and it'll download locally to your drive. And you can send me a direct message. If for some reason you're having problems with that, I can pop it over in your email. We'll make sure that you get that for yourself. Last but not least, we do have a survey. So it's 5 questions. It takes less than 90 seconds to complete. But the feedback that you share with us in those 5 questions, we then share with our partners over at the Central Valley Regional HR Hotline. And collectively, we just make sure that we're providing you with an entire suite of resources, trainings like this that are going to help you the most and help bring you peace of mind. So please either click through on the QR code that you'll see on a slide. I'll also drop a hyperlink into the chat to make it easy peasy. Now I have the great privilege of introducing our trainer today. We have Astrid Servant, who is one of our amazing HR directors. If you have called into our hotline, maybe you have spoken with her. And I know we have a lot of ground to cover, so Astrid, it's all yours.
Great. Thank you so much, Anna, and welcome everyone to the top 10 ways to stay out of court. We're going to do it, if you're old enough to remember, David Letterman style, the top 10 ways to stay out of court. We'll start with number 10. But before we do that, just want to welcome you to today's webinar. If you're here from Central Valley counties, there is a specific hotline number that you can utilize to get in contact with CEA and talk to one of the HR advisors 8 to 5 Monday through Friday. It's such a great resource that your county provides. So please make sure you note the county in which your business belongs to, and tell a friend, tell a business friend that this exists. We help with any kind of counsel, not counsel legally, but any kind of HR help as it relates to anything employment related, from the onboarding process all the way to the termination process and everything in between. So we welcome you to call in and discuss anything HR related that we can help you with. What we're not is a law firm, so we can't give you legal advice, but we are an HR consulting company. And a lot of times we get you to the place where you need to go to maybe speak to a lawyer. And so we save you some money there by kind of analyzing the situation with you and getting you to that point. Our whole goal is to provide peace of mind to employers throughout California. And we have sister associations in other states as well, but we are California Employers Association. We manage that HR hotline that we discussed earlier. And then we also offer membership. So if you need additional HR support beyond what the HR hotline provides, because the HR hotline provides just very quick, easy questions, answers to things that you might be handling in your workplace. But we also offer membership, and that's anything from recruiting help to on-site HR assistance help to training, such as this one for your employees. We do it on-site, we do virtual, we help with handbooks, we have fact sheets, all kinds of documents and toolkits that you may need. So anything that you need HR related, and again, if you need a little bit extra help, you can do a lot of things a la carte by visiting employers.org or by becoming a member. Okay, so like I said before, we're not a legal law firm. We are an HR consulting company. So we do not, you should not rely upon this presentation as legal advice or anything legal related. We are going to talk a lot about how to stay out of court. So a lot of laws are going to be discussed, but it's educational. And if things come up, I encourage you to utilize that Q&A box or the chat box I think the chat box is okay for me, Anna. So if you want to pop in on the chat a question as we move along, I'm happy to answer that way, so long as as long as we're doing okay on time. Okay, so what are we going to cover in the training today? We're going to learn how to start and end employment relationships in the best way possible. So a lot of best practices are going to be discussed today. We want to ensure your policies and your employee handbook are current and compliant because that's one of the big things here. So we'll talk about that. That's part of the top 10. And then another top 10 is avoiding costly fines when it comes to meal and rest period violations. What California is so unique when it comes to meal and rest, and also employee classification, ensuring that we have hourly and independent contractors classified correctly. That's very different than federal law, so we're going to discuss that in California. And then how to proactively address potential harassment issues before they begin, because a lot of times that's what makes us go into court, are these harassment discrimination claims. So that's what we're going to get to as the webinar goes along. So, top 10, rounding out top 10 is strong hiring practices. We want you to hire slow. In fact, we have a presentation called Hire Slow, Term Fast. So we want to start the beginning process, engagement of the employee process and applicant process slowly. We want to have new hire orientations for our employees because they set the tone. You may have a small business, but the new hire orientation is still very important. So you want to make sure that you utilize, even if it's a 30-minute to 1 hour orientation, where you're setting the tone for your company and you're reviewing a lot of important documentation. Yeah, that's where you're going to review the employee handbook. Employee handbooks are not legally required, but they are a very good idea. And a lot of documents are required for employees to have. So might as well put them all neatly packed into an employee handbook. But if you are going to have an employee handbook, ensure that it's updated, because it can, just as much as it can help you, it can also harm you. So we're going to review that employee handbook in that process, include an at-will clause because we are an at-will employer. What does that mean? We're going to discuss that at-will disclosure in that handbook that says either you or me, we can, either one of us can terminate that employee termination at any point. Sign-off sheets. If you have those, if you have something that you need to sign them off on, ensure you have a checklist with you. You're going to have those hiring documents, and we'll talk a little bit more about that. And then it is a tough recruiting market right now, probably more than ever. So consider building in flexibility rather than offering it as a perk. We used to say, look, we offer this kind of environment or time schedule. Now it's almost like, we're a flexible work environment. We will work with you, because when there's flexibility, so long as you're consistent in applying that flexibility, it's going to work a little bit better to attract talent to your workplace. So what do we mean by hiring slow? It means take your time. Know what you're hiring for. Know what that job description is before you put that posting on. Remember, a job description is different than a job posting. So you want to, a lot of times we have antiquated job descriptions out there, antiquated job postings that we've been using for years and years and years. You may be new to this position and you acquired it and you're keep using it, but relook at what it is that you're hiring for. The times have changed. A lot of the employment processes, the way we conduct business has changed. So let's take a fresh look at those job descriptions and the positions, and then determine what you need. Is this a full-time position, a part-time position? Really put thought into it. Am I going to offer benefits or not? What does that mean? Am I going to hire more, maybe a higher caliber employee if I offer benefits versus not? So hire that right person for the job. A work relationship is like any other relationship. Don't jump into it without doing your research first. And it's pretty easy more than ever to do some of that research. Some of it is legal and some of it is not. So make sure call into the hotline to say, is it okay for me to, for example, stalk someone on Facebook or Instagram and take a look at their postings that they've had? Can I do that before I hire them? You may not be able to. So yes and no on that one, maybe, but make sure that you do your homework and you're doing it in a compliant way. Some potential interview landmines. So, and train your supervisors, your leads, whoever it is that's interviewing, maybe it's you, on what it is we can ask applicants, because this is a huge one. This is why we hire slow and we take our time. And this is why it's a top 10, because this can land us in court. We want to make sure we stay away from questions that are protected. Age, family status. We're going to talk about all the protected classifications towards the end of our webinar, so you'll have that slide. But just make sure you're not asking about anything that's under the protected classifications. And if you're aware of what they are, you'll know that there's a lot. So you want to be mindful of what you can and cannot ask during the application process. We're not going to ask questions about salary history. We are unable to do that in California anymore. You do want to ask what they expect to make on this position. And now we also have the posting, most of you, because if you're a large enough employer, you're going to have the salary information on the job posting anyway. So there's kind of that expectations kind of taken away now. We both know how much it's paying versus how much you made, but we're not going to ask them how much did you make in the previous position. No questions about criminal history. We can't do that in California either until after a conditional offer is made. This is kind of an area that is, there's a lot of charges against employers coming up right now because of this, because employers are unaware that they shouldn't be asking for criminal history until after a conditional job offer is made. And even then, even after a conditional job offer is made, there is a whole procedure that you must follow if you're going to rescind the offer. It can't be as easy as I ran a criminal history background check on this applicant and I didn't like what it said, and so I rescind my offer and I tell the employee, the applicant, hey, look, I ran a background check and it came back with information on it. I'm rescinding the offer. That can't happen. There is a whole process and procedure in California, and when that happens, call into the hotline. We have the templates for you, and they're free that you can use should that happen to rescind that offer. An applicant needs notice. They need to have time to give you more information regarding that criminal history before you rescind that offer. So focus on questions about the job and how well the applicant can perform it. You're really getting to know each other in that application, that interview process. It's getting to know each other as best as we can before we make that job offer, so that when we make it, we know what we're doing, both parties. All right, so number 9, that's number 10. So number 9 is California's many leave laws. And it's impossible for me to review them all with you today because we have a 90-minute webinar just on California's leave laws, but I'm going to give you the most important. Just know that there's 20 laws covering protected leave. And what you should know is that when an employee says, I need to take time off for X, that X might be protected. So you need to check with your HR, call into the hotline. They told me that, the person that they care about is sick and they're in a different state. Can I give them time off? Or they themselves are sick, their child is sick. How long have they been with you? We'll ask all those questions for you because each leave law works differently. Not all leave laws apply to your business. It depends on your head count. And when you're looking at head count, you're looking at every employee that's under your umbrella anywhere in the universe, and not just your California employees. You're looking at everyone. So if you have out-of-state employees, out-of-the-country employees, they will probably count for your head count almost on all these leave laws. They may not for benefit purposes, but for leave laws, they do. So it's only going to apply to your California employees, but the head count would apply to see if you are an eligible employer. Paid sick leave is for all employers, no matter what headcount you are. If you have a California employee, you must offer paid sick leave. So I will review that one quickly. You know that that went up, that has increased for 2024. You now must offer 40 hours or 5 days off for all employees to address their own personal needs or that of their family member. This is a job protected leave, sick leave, meaning you can't deny when an employee takes sick time. You cannot ask them for a medical note before paying out sick time. This is protected time. So anything you do to deny sick leave would be looked upon as retaliatory. Quick way to get you in court if you do that. So be careful with the sick leave. You do have options on how you offer sick leave, and that should be detailed in your handbook. You can do a lump sum, meaning I'm going to give you all 40 hours in a bucket, 5 days, beginning now or at 90 days. Or you can do an accrual, and the accrual has to be at least 1 hour for every 30 hours worked, and then you cap that at 80 hours. You're going to cap it at 80, but you're going to limit the use to 40 hours in the year, which gets a little tricky. So again, if that's confusing or you need more information regarding that, call into the hotline. We'll explain it a little bit slower. But just remember with sick leave, if you have it as a separate bucket from your vacation time, then it's not paid out at termination. With vacation is paid out at termination, sick time is not. You can say an employee starts accruing day one, but you cannot use it until the 90th day of employment. So that's okay. You know that we now have a designated person. That used to not be the case. It was only certain family members, but now an employee can designate a person other than the family member to be someone that they want to take sick leave for. And then remember, if you have employees working remotely or somewhere else outside of in an ordinance that provides more sick leave, you do need to follow that ordinance. So if you have drivers driving into San Francisco or San Diego's 40 hours, I think. But if you have it in LA, somewhere where they offer additional sick leave, then you do need to follow that ordinance in that. So the minimum is the California, but if you have employees working elsewhere, for those employees working elsewhere, you need to provide that additional leave time. Okay, so be careful with that as well. If you're not sure if your employee works somewhere, Santa Monica, let's say somewhere, and you're like, I don't know what that is, that's what the hotline's for. Give us a call. The other one that's very unique to California that I want to discuss, because again, if we get this wrong, it lands us in court, is the pregnancy disability leave. It's for employers with 5 or more employees for 20 or more work weeks in the current or preceding year. So even if you only have 4, if you had 5 in 20 or more work weeks in the current or preceding year, then you are an eligible employer that has to offer PDL, and it's going to provide up to 4 months of job protected leave. Most of the time, it's not going to be 4 months because most women are not disabled for 4 months for pregnancy, but it can be. So it can be for things related to pregnancy, such as morning sickness, up until even having the baby. So it can be up to 4 months, but more than likely, it's going to be more like 8 weeks or so, 6 to 8 weeks. It is employees are eligible at his date of hire. So this is one where if you have 5 or more employees, an employee is going to be eligible on day one. If you didn't notice they were pregnant, didn't know they were pregnant, which you shouldn't discriminate against anyway, and they have to go out within 30 days of them starting, this leave will protect them. You're going to have to provide that reasonable accommodation, job protection, and this is not something that runs concurrently with FMLA, with CFRA. So again, that's confusing. Give us a call. California Family Rights Act is another leave law that's unique to California, very similar to the FMLA, but different. So the family members, our definition is different. We use it for baby bonding, not for child care, not to take care of the child. That's for pregnancy reasons, so very different. And then your own serious health condition, that's similar to FMLA, and then family and armed forces, and then family care. So the blue and the pink are very similar to FMLA. The others are more unique to California. So again, this is going to provide 12 weeks of unpaid leave of absence for employers with 5 or more employees. Another unique one in California that just became a law, and it was last year, but I want to mention it, is the bereavement leave. Employers with 5 or more employees, you have to provide 5 days of unpaid bereavement leave. And I won't read off this whole slide, but just know that this is something that is unique here. We want to make sure we get it right. It is an unpaid leave, but it is job protection for employees. And this is per death. So if unfortunately someone has a grandparent die in January, maybe another grandparent die in July, this would cover per leave. And you do need to allow them to use vacation or sick time. And if you have a paid leave for bereavement, because many employers do, that's okay. You can combine it too. A lot of employers have 3 days paid and maybe the other 2 unpaid, just as long as you get them to 5. In 2024, we also have the new protection from Senate Bill 848, which is the reproductive loss bereavement leave, different from this one. And this is going to cover employers with 5 or more. So just remember there's that one too. A lot of times we just combine the 2 leaves into one, but they're for separate reasons. Reproductive leave law is for any kind of reproductive loss. And that's defined as a failed adoption, failed surrogacy, miscarriage, stillbirth, or an unsuccessful assisted reproduction. So again, and that's per pregnancy too, or per failed miscarriage, whatever that may be, the reproductive loss. And the unique thing about the difference, I guess, between these 2 leaves, the bereavement and the reproductive loss, is with bereavement, you can ask for documentation, substantiation, so long as you put it in your policy. But with the reproductive loss, we can't. That is a very confidential leave law, and we cannot ask for substantiation with that. So just know that that exists. Okay, so that's number 9. Let's go to number 8. Ensure exempt employees are really exempt, because this is a common one we sometimes get wrong in California. Cannot follow the federal one. It's a very costly mistake that employers get in trouble for. As you can see here, 90 million to 2,400 claims adjusters at Farmers Insurance Exchange for misclassification because it resulted in unpaid overtime because they classified incorrectly. um, then they didn't pay overtime that was due. And I'm sure you have seen lots of class action lawsuits against this kind of stuff. I just got one from when I worked at long years and years ago, that somebody is doing a class action on a company. So this is a huge win for defense attorneys that are really looking for money. It's an easy way for them to get a payout, and very costly to employers. So as you can see here, Long Drugs got in trouble for that. They had assistant store managers that they classified as exempt when they were really hourly, because exempt managers have to do at least 51% or more of their job as an actual manager. And at Long's Drugs, they were stocking, they were cashiering, they were doing a lot of other things, and not so much they were managing, but just not enough time. 12 million settlements in Taco Bell for overtime violations for employees in California and Washington. So lots of big, huge lawsuit payouts here. So we want to make sure we get this correct. Remember, an exempt or a salaried employee has to pass two things in California. They have to pass the duties and salary test. So they have to make at least 2 times the state minimum wage. And they also have to meet the job duties. Their job has to actually qualify for that. So let's look at that. So the white collar exemptions are the most common ones, but each of these categories are subject to a specific duties test. If you're a CEA member, we have the analysis for you. So analysis worksheets that take you through and kind of force you to answer questions to see if they meet the criteria for executive, administrative, professional, which are the most common ones that we see for exempt employees to be salaried. So exempt, what does it mean? It's exempt from wage and hour laws versus non-exempt. Non-exempt will be your hourly employees. So your hourly employees are paid by the hour for every work that they perform, and there is a requirement to keep time. So another way, again, that can lead you to court is you don't keep time. I have done audits where employers are like, we don't have timesheets, we don't have time clocks, we just pay them 40 hours. But that's not compliant in California. We have to have some sort of way to document what the employee is working so that we can prove that we've paid them correctly. And that includes lunch and meal periods as well. We need to document that meal period and when it was taken, because we need to make sure that we take it by the 5th hour. So timekeeping requirement is something that's required. Breaks do not have to be documented. They can if you'd like, but they don't necessarily have to be documented. And if you are going to document when a break is taken, make sure you're consistent about that, because if you're inconsistent in a department or you forget to do it, that creates risk. It looks like, it appears like you didn't give them a break then. So if you're going to do it, just make sure you're consistent. So we know that they get lunches by the 5th hour, overtime, and then you have to know which wage order you belong to. The wage order is something that's posted next to all your posters that you have in your break room. Make sure you know which wage order your company belongs to, your industry. That wage order also tells you how you pay out your hourly employees. Okay, so you know that minimum wage went up for 2024, and now this is what the minimum wage and the exempt salary is, regardless of size. We are all used to be where if you were a smaller employer, you could get away with less, paying less, but we do have these minimums that we need to keep, and if you have employees who are minimum wage or salaried employees who are at the minimum of the salary threshold there. And this has caused a lot of employers to rethink, do we really want to pay our managers this much money? I think we don't. And so they can remain managers, but now we're going to make them hourly. So we do have a little bit.ly here, a little link of how to transition an exempt employee to an hourly employee. That might work better for your kind of moving forward. If this continues to go up year after year, which it is, then we may get to the point where we just, for budget reasons, need to transition them to an hourly. Just know that when you transition a salaried employee who's not used to doing that, we got to remind them, you got to log your time, take your meal periods, be careful with overtime, that kind of stuff. And then remember this, I discussed kind of the basic minimum requirement for minimum wage, but there are local ordinances out there that apply. So if your employees are stepping foot into, again, San Diego, LA, Santa Monica, Pasadena, San Francisco, up in the Bay Area, if they're driving to these counties, training, doing any kind of work there for more than, typically it's more than 2 hours, then the leave law, the sick leave and the minimum wage would apply. So just ensure that you know where they're working. Call into the hotline if you're unsure, and we can help you with the ordinance in that area. Okay. Number 7, rules for non-exempt or hourly employees. We talked about that a little bit. Meal and rest breaks, no required number. We're going to go through what the rest break requirement is. Overtime, no rates based on hours worked, base rate of pay. Wage statements, no all required elements. You got to define your workday because a lot of times they may not even reach overtime. We get this call into the hotline a lot. My employee worked 7 days in a row. Do I owe them overtime? But the 7 days in a row fell on 2 different work weeks, or they worked maybe 10 p.m. to 6:30 a.m. or 10 p.m. to 8 a.m. Do I owe them overtime? You may not, depending on how you define the work day and the work week. And for that, we need a handbook to define that stuff. So we want to make sure for your business, how does that work? How do we define a work week? How do we define a work day? And there are defaults that the California will default to. The presumption is midnight to 11:59, and the presumption is Sunday to Saturday. So if that works for you, you're good. But if you want it to be different to, again, avoid maybe paying overtime or to figure out if we even owe an employee overtime, then you're going to want to take a look at the work weeks and the work days and look at your business and maybe define it differently if it works for you. Here are the rest breaks, depending on how many hours worked, what you have to allow them. An employer is to authorize and permit an employee to take 10 minutes of net rest time for every 4 hours worked. They shouldn't be taken together, which is a very common thing to do. Again, another way to keep you out of court. Don't do that. Make sure that they're taken because it says for every 4 hours worked. So we need to make sure they're separated. We don't have to record the breaks, the rest breaks, because it is paid time. And you don't need to police it like we used to all the time, but you do need to allow them to have freedom. They need to have a net amount. So sometimes employers say, look, it's going to take them, we have a big warehouse and they have to go through security, which is the case for Walmart and how they got in trouble and it landed them in court was because they had to go through security. I think Amazon too. And so now they just give them 15 minutes so that it allows them that 5-minute cushion to get in and out of the building and to where they actually need to be able to rest. If they can make it to Starbucks and back in that 10-minute break, you need to allow it. You can't police them to stay in your workplace. If you do not allow that rest break, the penalty is 1 hour worth of regular rate of pay if you fail to do that. And that's the same penalty for rest breaks, for meal breaks. If you fail to give a meal break or fail to give it on time, the penalty is 1 hour of pay at the regular rate. And by the way, that 1 hour penalty pay should be a line item on that pay stub. You don't just pay them an extra hour of regular rate, you pay them an extra hour of penalty pay of a meal period violation or rest period violation. Remember, for meal periods, you're looking here how many hours worked, how much meal periods they need. You do need to relieve them of all job duties. Ensure having a disclosure in a handbook is golden. It's going to save you if you're in court where an employee is saying, "Well, I didn't know. I'm not sure." Well, your handbook says it. It says that we're relieving you of all duties, and it's your responsibility to take this. We do need to ensure that we're allowing and that we're making it possible for them to take a meal period, meaning we have enough coverage for them to take that meal period by the time that they need to take it. We can't round any kind of meal periods. In fact, the law just came out. We can't round anything anymore. It used to be we could round things. When then came we can't round lunch. Now we can't round in or out as well. So make sure we make changes to our time clock that we're actually tracking actual time and we're not rounding to the nearest 15 minutes or the nearest 5 minutes, as that is not allowed anymore. Some meal and rest deal breakers here that again can get you in trouble if you do this. Very easy way to stay in court. So we want you out of court. So we make sure that we have again these disclosures in a handbook is great. Review them with those hourly employees when you hire them as well. Remember overtime, don't get stuck on this. This is an easy one. You have to pay anytime an employee in California works more than 8 hours in a day, more than 40 hours in a work week, and then for the first 8 hours of the on the seventh consecutive day of the work week. That's where we need to define that work week to ensure that we have defined when that is to see if we owe them overtime. And then 2 times regular rate of pay for anything over 12 in a work day, and then on anything beyond, if they're working 7 days in a row, on the eighth hour on that seventh day in a row needs to get paid too. The rounding, yeah, it may not be on the clock in and out. That law just came out, but I don't know that it's in effect yet. So yes, thank you for that. Someone just wrote that into the chat. The meal period, yes, the meal period has definitely been defined already, but the clocking in and out just came out, so probably not in effect yet, and I don't know if it will retro. So let's watch out for that. We will definitely have something for our members, and if you subscribe to CEA, we'll have that. I believe we're having that in a blog very soon, probably by the end of the week. Okay, overtime is based on regular rate of pay, not hourly rate of pay. So ensure you know what regular rate of pay is. It is different. If your employee has two different types of rates of pay, that we're paying the regular rate of pay and not the hourly rate of pay. There is a difference. I talked about wage statements quickly. We want to make sure that we put that premium pay. So premium pay, if an employee fails to provide a sufficient meal period or break, that it has its separate line item in that wage statement, so that we're not in trouble. And we know in California, it's a requirement to have quite a few things on a wage statement. So let's make sure we get this right, because an easy way for, again, for an attorney to pick pick apart your wage statement to see if you've missed something. Number six, avoiding misclassifications of independent contractors. So just like we said, I'm going to actually show you this next slide. We define what an employee is. By default, a worker is defined as an employee in California. So if you have anyone doing work for you, it defaults to an employee. An employee is anyone who performs services for the benefit of an employer. It includes minors, undocumented workers even, but employees are not independent contractors or interns. You must meet the definition for these if you're going to not have them classified as an employee. So we want to make sure we get the independent contractor correct. As a general rule, again, the person's going to be an employee unless they can prove an ABC test here, which is the following: is free from control and direction of their hirer, performs work that is outside the usual course of the hiring entity's business, and is customarily engaged in a trade, occupation, or business of the same nature as the work performed. And we're going to say, if you think that you may fall into this, then consult with counsel to be double sure that you feel like your independent contractor is definitely an independent contractor. There are a few exceptions as well, actually quite a few exceptions, to certain professions that automatically fall under independent contractor and may not have to follow the ABC test. We follow the old Borello test for those. So if you feel like you're not sure, always call into the hotline. We'll kind of review the ABC with you, or the Borello if it applies to that, and go through which ones are exempt if you're unsure. And like I said, we get you to that point where we may say, and if you're still not sure, we may then ask you to consult with counsel, recommend that for you. But you want to make sure you get this right, because if we don't, those mistakes are very costly, because that means that your employee didn't get a wage statement, didn't get paid minimum wage, overtime, didn't track time with the timesheet, and so on and on and on. Those fines add up very quickly when we do not classify correctly. Okay, we're at number 5, halfway there. Prevent and promptly correct harassment. This is one that I know if you watch the news, you see that this is probably a big ticket item that gets employers in hot water. We have to have mandatory harassment prevention training for employees every 2 years in California. Professionalism and respect in the workplace. Again, this is why a handbook is recommended, because we're going to talk about civility and professionalism in the workplace. And now we have to be a little careful, because there are new rules that say you can't limit an employer's right to complain, which we're not doing that. Employees are free to complain. However, we still need to do that in a professional manner, in a respectful manner. And so those policies should be in your handbook. We should talk about them as well. We should regularly discuss these with employees. Harassment can occur anywhere, anytime, and we should encourage that open communication, open door policy. So develop a harassment prevention policy that's going to outline what the complaint process is, who do I complain to, confidentiality, and the limitations of confidentiality. They need to know that too. Just because you complain doesn't mean I offer you 100% confidentiality. We do need to ensure that that employee knows we're going to keep it safe and only share it with those who need to know, and that there's going to be a timely response. California actually requires that. They're going to require a several step process when an employee complains about harassment or discrimination. So to be compliant, you have to follow that law. And your harassment policy has to include all those pointers that California requires. And we have to give that employee that at new hire. So that's part of your new hire packet. And again, even if you have a handbook that goes through that policy still needs to be printed out and given to your employee, or given to them through an intranet. They have to acknowledge receipt of that policy. So let's make sure we get this one right, and then train our employees for 5 or more employees. California businesses, again, with those 5 or more employees, have to provide training every 2 years, 1 hour for your non-supervisors and 2 hours for your managers and supervisors. And California defines what a supervisor is. So it could be someone that is a lead that may be getting complaints, or maybe tells people what to do, and has some sort of direction towards the employment process. So who gets hired, who gets fired, they get input. That person may qualify as a supervisor in California's eyes and should receive the 2 hour training. Remember that new hires and promoted supervisors must receive the training within 6 months of assumption of the position. And then if you have seasonal or temp employees, or any other employee that's hired to work for less than 6 months, they have to be trained within 30 calendar days after the hire date, or within 100 hours worked, whichever is first. Keep an eye out for investigation triggers. So, because we can easily keep these claims out of court. And if you need help because maybe you're a small employer and you're not sure, that's when you call us and we can help you. Again, if you're a member, it's a discounted rate. If you're not a member, we can still help you. We do investigations where HR leads the investigation. We help your HR department with that investigation. We can do a lot of the interviewing, talking, or give you guidelines for how to do that. Or if it's something you want to be independent of, you want us to do it, just you don't want to be tied to it at all, you don't want to be in the room, you don't want to be involved, then we have an attorney who can do it for you. That does need to be attorney led if you're going to be independent and want us to do it on your own. So both options are possible. It just depends on what's going on, what the scenario is, what the investigation entails. But some investigation triggers here for you to know about. If you knew or should have known, that is something legally that California defines. Does the employer, did they know or should have known about this? Whatever that could be. If there's suspicion of conduct that would violate the company rules or expectations, that should be something that, that's a red flag. Let me go ahead and look into it. Maybe it's something you observed. Of course, when employees complain, formal, informal, or even an anonymous complaint, you're going to be investigating. If you get an administrative charge or lawsuit, that's obvious, you have to investigate. Any kind of unexplained changes in your work environment. Maybe you have a shift that continuously calls out, or people who report to a certain supervisor seem to be unhappy suddenly, or there's high turnover there. That should be something that is, again, a new or should have known area, and you need to investigate. Or, of course, the classic persistent gossip and rumors that I know as a supervisor and manager we get tired of hearing and we just dismiss it, and that can land you in hot water. So don't dismiss it, even if it's the 10th time this employee has complained or is gossiping or rumors. Let's make sure that we look into it thoroughly. Number 4, follow and keep your employee handbook updated. And again, this, as like I said in the beginning, an employee handbook can harm you or it can help you. We want it to help you, but the way it's going to help you is if it's updated. And for 2024, if you hadn't updated your handbook, this is the year to do it. We do our labor law updates, and the number one recommendation coming out of our labor law update is update your handbook, because there's been so many changes in 2024 that we want to make sure we get it correct. So we want to have the confirmation of the at-will employment statement, because that allows the employee to know and for the employer to know that this is a two-way relationship that either one of us can terminate at any time. Now, I say that, but we say that loosely because we still have discrimination laws and harassment laws and a lot of protected categories that apply. So just because we have an at-will statement doesn't mean that we can just terminate an employee. We have leave of absences that we follow too. So it's great. We have to have that at-will statement in our handbook, but just know that just because we have that doesn't mean we have you know, we can just automatically terminate. We still have to consider so many different things in California before we do that. Required policies and notices should be on there, and they could be very unique to your work environment, that you have maybe proprietary information that you want to protect. So we want to make sure that we put those notices on there. And it's going to set the expectation for the employee that we actually have rules that we follow, and know your handbook. Know that you actually follow them. Don't have a handbook where nobody knows what it says. Your supervisors are unaware of it. Again, we even do a whole hour webinar on handbooks and what does the handbook say? Because sometimes they can be complicated things, and we want the handbook to have a positive tone, and not just a positive tone, but one that is readable. Not doesn't have a lot of legal jargon, because that's something that turns off an employee, and I'm not going to read it. So it's no good if just your HR person knows the handbook. It should be in language that's plain and that sets a positive tone for your employees. It's going to have consistency, uniformity. We are applying policies consistently throughout our staff, and it's going to be a great defense of harassment allegations, because it tells the courts if you get charged, because we can't prevent a charge from coming at us, right? But if we do get charged with something, they're going to ask for that handbook. Do you actually have a disclaimer that says we do not tolerate harassment and discrimination in our workplace? And did you have reporting procedures? Did you have ways for an employee to report this kind of harassment, or what are they supposed to do? And you wouldn't believe how many employers I've seen, and I've worked in HR a long time, where employees are like, well, I just don't know where to go. I don't know what to do. I don't know if they're going to believe me. And they don't know, because there was no handbook, or they just maybe didn't read the handbook. It wasn't really pointed out to them. It was just given as a link and never reviewed. And so that employee really is lost about it. And when they're lost, they're not going to go to us. They're going to go outside the agency and find someone else to report it to. So again, another big reason why we want a handbook. It also is going to talk about benefits, sick leave, all the leave of absences, vacation, layout, and then of course healthcare benefits as well. Some required versus recommended policies here you're seeing. I mean, there's a lot more than this, but these are at least some of the required policies that you have to have for your businesses. Lactation accommodation is often missed. It is something that is required for all of your employees. FMLA, CFRA, PDL if it applies to you, and most of you are going to at least have the PDL and the CFRA leave. Paid sick leave, make sure that's updated. It's not the old policy, that we actually have the new policy on there. And if you have workers working in other cities or ordinances, make sure that you have that as well in your handbook. We're going to have our recommended meal and rest breaks. I have seen employers be saved by their handbook because they put out their meal and rest break, where the employee says, I didn't know. That's not what we normally do. And the employer could show their policy of how we did tell you to take your meal period by the 5th hour. We did tell you when overtime was worked, or that overtime had to be authorized before you worked it. Means we still pay the overtime, but we can discipline you now for working unauthorized overtime. Vacation, remember, we can't have a use it or lose it policy. So we want to spell out vacation. Vacation is a very tricky thing, because again, vacation is not something we have to offer. But if we do offer it, California polices it. California says you must have it work this way if you're going to have vacation. So we can't have caps, or we can have caps, but it has to be a certain amount, a time and a half at least for a cap. We can't have a use it or lose it policy, meaning you have to either pay it out or allow it to roll over, or schedule it for the employee, but they can never lose it. Once an employee earns vacation, it's theirs forever until they use it or it gets paid out. So that's why we pay it out at termination as well. So make sure that you get the policy written correctly in your handbook. Same thing goes with holidays, not required to pay holidays, but if you are, unless you're a federal contractor, sometimes you do, but holidays aren't required. However, you want to get it right. Floating holidays, things like that, they don't exist in California. You can have a floating holiday. California is just going to recognize it as an extra vacation day or as a depends on how you define that floating holiday. So let's make sure that when we write policies like this that sound good and that we think we're doing good, that we make sure that they're compliant as well, because that can get you in trouble. Number three, we're almost here. We're rounding the top three here. Insurance and your business. Workers' compensation, remote, that is required. You have to have that. Know your carrier, know the process, and make sure that not just you, but any kind of line manager, any lead, they know the procedure. If you're not there at 2 p.m. because you're out sick, or if you're not there at 10 p.m. because that's not when you work, that person in charge needs to know who to report a workers' comp to, where the forms are at, know the process, where the clinic is that you're supposed to send employees to. This is an easy one that we get wrong too sometimes, and it's very costly. The penalties are very high because we didn't get it right. Employment practices liabilities, again, protection against claims made by employees, former employees, potential employees. You want to have that insurance. Again, also discrimination, harassment, wrongful termination, and wage and hour. These are things that are very costly to employers. So we want to have these things set in motion and ensure that we have them in place before we get charged with something like this, because they are very costly. Number two, use effective discipline and documentation. And we do a lot of training on this. If your employer needs maybe coaching training or communication training for your staff, our training team, our soft skills training teams is great. We do compliance training, but we also do this kind of stuff. So we'll touch upon it a little bit here because it is something that employees will point to being treated differently, or I wasn't given a fair chance. So we want to make sure we cover this as a number two. This is a very big one, that we get it right. So we want to make sure that we're saying the right things, because sometimes what we say can get us into hot water, and that we're documenting. And when we document correctly. We're leaving emotion out of the documentation, because that emotion sometimes can get very personal, and then that gets us in trouble. So we want to make sure, I'll always say document and then maybe have someone else read it, that's a peer, or we even get people call into the hotline, hey, I wrote it this way, what do you think? Because we want to make sure that we don't write down what is discoverable. All this stuff is discoverable if you are charged in a lawsuit, and so we want to make sure that we state the problem and just the facts, the detail, the consequences. Don't be vague, detail the consequences without emotion, just the facts. List ways you will help and express your genuine commitment to support them. We're going to provide additional training by Bob. Bob will provide you additional training twice a week. They'll meet you at this department to go over your checklist, and then get their signature, get their buy-in on that, whether it be a coaching or whether it be a written warning. We want to get their signature. If they refuse to sign it, that's okay. They can refuse to sign. You're going to say refuse to sign on there. And that also tells a lot of the employee. I always tell the employee, write refuse to sign, and that kind of gets them to sign something. But even if they're saying refuse to sign, make sure that you memorialize it and that you date that as well. Make your work decisions based on work factors only. Remember, I'm gonna show you the protected classes next, but your line manager should know all these protected classes because we need to be aware of them. We can't say the wrong thing. We want to make sure that we're aware that we're not treating people differently because of those protected classes. Make employee decisions based on work factors. And we get a lot of calls, and my colleagues will tell you the same thing. They will say, well, I was being nice. I didn't talk to them for the first 6 months about their performance because, hey, I knew that they were going through some things. And so I was being nice. But, we really had this problem for the last year, but I didn't document it. And so, too bad, because you didn't document it means we have to start from step one. So we really need to, the employee is not going to say, yeah, you've been talking to me for the last year. More than likely, they're going to say, what? This is all new to me. And so we need to make sure we're documented, that we're laying out the work performance issues, or if there are attendance issues, if there's safety violations, maybe they're not wearing the proper uniform, or violation of company policy. Those things are not treating people different. We're actually just calling you out on a policy violation. So those things need to be documented in order for us to move forward with that employee. And that employee has a right to know. And maybe if supervisor looks at it from that perspective, is the employee has a right to know what they've done wrong so that they can correct it, maybe make a different decision. Maybe this isn't the right place for me, but now you've called it to their attention and it's on them to now make the next move. What are they going to do with that information now that they know? So as you can see, we have a lot of California protected classes here, as you're seeing. And I don't know that I'm seeing the cannabis protection, which is new. So just know that there's an added one, cannabis protection as well. So we cannot discriminate against an employee or an applicant for any protected class here listed here, including cannabis use outside of work. So ensure that your line managers, anyone interviewing, we're not asking questions regarding this, and that we're not making employment decisions based on this. And if an employee happens to fall under this category, then we're going to be a little delicate. We're going to be a little bit extra careful about how we discipline to ensure that it doesn't give the appearance of discrimination. And that can be tricky as well. Always give us a call if you want to run through some of this stuff. Sometimes we ask you, does an employee fall under any protected class? That can create additional risk, and we may maybe advise you to go a different route, or you may consider maybe giving another warning so that it doesn't give the appearance of discrimination based on a protected class. What can we do as managers here? We can require employees to focus on the work that they're performing during their work hours. Remind them that the office dialogue needs to be civil. We can't prevent employees from talking about things that they feel are unfair, or if they're bringing attention to maybe their wage, that those are things that we can't, we can't prevent them from talking about how much they make at work. They can disclose that, or how much they made on a bonus. But we do want them to be civil while at work, and we should have those policies in place. We sometimes it's getting a little more difficult for employers to restrict what employees can and cannot say, but I said tricky, but we still can do it, and we still should be doing that. Enforce harassment prevention policies or other workplace respect policies, because what they may think as their right to do might be violating someone's protected status. So we need to be careful, and that happens a lot with political stuff, which we'll talk about next. Actually, yeah, we'll talk about next here. Don't allow politics to be used as a cover for harassment or discrimination. Know that those employees have protected rights under our protected classifications. Enforce use of technology policies. If they're on social media outside of work, what can and can they not post? That should all be spelled out in your handbook. Allow space to respectfully to defer. We are all different, and that's okay. And as so long as we treat each other with respect while at work. So employee discipline, know that, again, your policy should state this as well, that they're going to be subject to discipline if they violate any kind of policy. Where an employee's conduct provides a legitimate non-political justification for disciplining an employee, then employers can act. And ensure that your personnel policies, your handbook, are applied evenly across the political spectrum. If this is something that is happening in your workplace, be delicate about it. Give us a call, and we'll kind of help guide you through that. We've gotten to number one, so thank you for staying with me through the end here. Number one is fire fast with no surprises. We want to make sure that when we get to the end of a relationship with an employee, that there are no surprises, that we've actually covered everything, that they saw it coming. And if they don't, there's other ways to do that as well. We're going to be careful about that. But we really want the employee to know we gave it a fair shot, but it's time to end the relationship. So we're going to have the proper paperwork in order depending on what is driving that termination. We're going to make the process quick and fair. We don't spend a lot of time. Our new hire checklist is very long. Our termination checklist is very short. Those meetings are pretty quick. We want to be professional. Again, we prefer there to not be any surprises here. But we want to make sure that we treat them with respect, and that we review why it is that we've gotten to this point of termination, and then have the termination forms that you are required to give them available to them. We have that DE 2320 for your benefit. That's a little blue pamphlet that's very long. You can send them the link or you can give them the pamphlet. The pamphlets are actually free if you want to order them through the EDD website. Notice to health insurance premium payment, or HIP. That's actually a different one than COBRA, but that is one that will tell them about the exchange there in California if they want to pursue any kind of medical. And then notice to employees as change in relationship. That's an unemployment form that is basically saying our status has changed. You used to be an employee, you are no longer an employee, whether that be an involuntary termination, voluntary, or a layoff possibly. We also sometimes use it when an employee goes out on leave of absence because they're on a long-term leave of absence. And then continuation of coverage under COBRA if they had medical benefits through you, and the continuation of that COBRA or CalCOBRA should be sent to that employee. That employee can get that later. It doesn't have to be at the termination meeting. And then the certificate of group health plan coverage. All that can come again later after the termination has been done. Pay at termination, remember, if it's an involuntary termination, you are the driving force here, you're saying you're fired, then the pay on the last day has to be done when the words leave your mouth. So if you're doing it remotely, we're making sure that you have a paycheck to you that day. If it's a voluntary quit with more than 72 hours notice, they gave you more than 72 hours notice, then the employer has to have that paycheck on the last payday that they are going to be there. If they voluntarily quit without the 72 hours notice, so less than 72 hours notice, then we owe them that pay within 72 hours of them giving us that notice. And 72 hours, 3 days, that would be calendar hours, not business hours. You can mail that final check for a voluntary quit only if the employee requests payment by mail. So you can let the employee know your check is available and ready. Document that you've sent them that text, that letter, that email, because that stops the clock for any kind of penalty pay that you might owe them if they don't receive their check. If they then say they want their check mailed, I would recommend getting that in writing and having them provide the mailing address in which to send it to, and make a copy of that before you mail it out. That date of mailing is considered the date of payment, if that's the case. Final pay should be a live or AKA manual check. Direct deposit is okay so long as you get a new direct deposit agreement. If you're a member, we have that form. So you have the direct deposit form they get at new hire, and then you're going to give them a new one if they want that final paycheck direct deposit. Remember to also pay vacation time. That needs to be paid out. If you have a PTO plan, that entire PTO plan gets paid out at termination as well. So some best practices here for that termination meeting: have a witness present if you're able to. I know some of you are small employers and it's probably not best practice to do that, but if you can, and if it's a very delicate termination, you can always reach out to us. We can also be present as well, either in person or by Zoom. Have the employee sign a voluntary resignation form if they are resigning. Conduct an exit interview or allow the employee to take that home. It provides a lot of good, valuable information to you. Use a termination checklist. If you're a member, we have that checklist for you so that you can make sure that you've given them every form that they possibly could need. So some takeaways here before I leave you for today: review your internal procedures for compliance. All this stuff is compliance related. We want to make sure we have it right to stay out of court. Train your supervisors and managers to ensure they know these policies. Give them a copy of this training so they know to be aware of it. Maybe a red flag to go to you and HR or managers. Have an open door policy and talk about that open door policy. Make the rounds. Make sure everybody knows who you are, that you are available for them to report something to. Better it be you than an outside agency or a lawyer who's waiting to take their money. Review policies, actually waiting to take your money. Review policies with employees to ensure clarity, make them readable, make sure that they are understandable, and then update your employee handbook at least once a year because we have those updates coming up. If you're a member, we update that handbook and you have our handbook. We actually provide the handbook updates every year. So if you have a CEA handbook, we'll provide those handbook updates to you. So if you want to consider membership, we have a monthly one that's only 109 and a different levels of membership as well. Thank you so much for being with us today. I'm going to put the there's the HR hotlines again for you all, and I'll throw it back to you, and I'll put the training codes up next as well. Thanks so much, everyone.
All right. Thank you, Astrid. Man, that is such an awesome training. I don't know how you get through all of that content
That's a
in
lot.
less than an hour. You are a seasoned pro. So if you call the appropriate number on your hotline based on where you are doing business, you may have the great privilege of talking with Astrid soon. As she mentioned, training codes today for continuing education credits, HRCI.
Oh, I think you went mute there, Anna.
Sorry, my friends, HRCI 656599, SHRM code 24-WDMSX. If you have any issues with those at all for whatever reason, ceainfo@employers.org, and we'll be more than happy to help walk you through it. And then, as I mentioned, we do have a quick survey. This really ultimately helps you all. So it's 90 seconds max. It's 5 questions, but your feedback really helps us and our partners over at Central Valley HR Hotline to continue, to develop these trainings for you. Speaking of trainings, I do want to put your attention on the chat. May 22nd is our next free webinar sponsored by Central Valley. That is going to be proper steps of a legal termination. So as she was talking about on the last one or two, that is a whole, like, there are entire webinars dedicated to each of these 10. So we really encourage you to continue to attend these webinars that are sponsored by our friends over at Central Valley. So we hope to see you then. Thank you again, Astrid, for sharing your expertise, answering questions. Thank you all for spending your lunch hour with us, and we hope to see you on May 22nd. Cheers.